I would ask that everyone put themselves on mute. Just to keep you could probably go to the next slide, Lynn's just our housekeeping. So the housekeeping is if you keep yourself on mute.
She said to put everybody on mute.
Yes.
She did.
And then if you want to use the chat, we would ask everyone to go in there and introduce themselves. Lindsay will be monitoring the chat, and Alyssa, another coworker, is going to come on and also monitor it. And if you introduce yourself on chat, and then you can also use chat to ask questions. Then we'll do some introductions. But I just want to go today. We have, I shouldn't say attorneys. We have two members from Illinois Prison Project with us today. Rachel Domain-White and Mira DeJong, and Lisa Daniels from the Prisoner Review Board is here. It's exciting. And we also have three people who have been involved with Clemency's. Latoya Baines was formerly in custody and filed her own clemency without the benefit of an attorney and was successful, and she's going to give you some hints. Susan Warsaw, she's a mom, and her son filed clemency. And she's got a little bit more of a story. But Susan, her son went in 2016, and they were filing some things with an attorney about trying to get the sentence reduced. In the meantime, she filed for clemency. They filed, and her son Avery was successful. And then we have James Swansea, who is on the Restore Justice staff, and he also had a successful clemency with, in fact, the help of an attorney. And after that, we'll be open to questions. So now we can just move on to a little bit about Restore Justice. Next slide. We work on state level policy reforms that impact people serving extreme prison sentences and their families, with an emphasis on youth and emerging adults. My name is Julie Anderson. Next slide. I'm the outreach director. My son Eric was sentenced in 1995 when he was 15. He's now 42. He has been resentenced. And he'll be out now in 2025. We'll just leave that up for a minute. And I am not sure on Illinois Prison Project. We have Rachel White Domain. Next slide, if everyone read that. Oh, we have Mira DeJong, who is the staff attorney with Illinois Prison Project. Mira works to bring people who are incarcerated home through a variety of methods, including clemency, parole, resentencing, and administrative advocacy. Mira, I'm going to leave this up for a few minutes maybe while you talk so everyone can read through it if that works. And are you ready?
I am, but actually, is it okay if we flip the order and have Rachel go first?
That's absolutely. We'll look at the next slide, which is Rachel's. Okay, I wasn't sure and I should have checked with both of you. I apologize. So this is casual. Anyway, Rachel White Domain is the director of the Illinois Prison Project's Women and Survivors Project. Rachel previously served as a policy director for the National Center on Domestic Violence, Trauma, and Mental Health, where she developed and managed a national policy portfolio to address systematic issues uniquely impacting survivors of domestic violence experiencing trauma-related mental health and substance abuse conditions. And I'm not going to read her whole bio, but it's certainly there for all of you to read. And we'll just let Rachel take it away.
Yeah, that's great. Thanks so much, Julie. We'll leave that up for a second, and then I'll maybe have you and Lindsay have you take it down just a minute here, just so I and the attorneys that I work with at Illinois Prison Project, we very much have a perspective that attorneys can get some things done, and that's great. But what is possible for attorneys becomes possible because of the work of people like you all. So people that are really doing the organizing, people who are directly impacted, people whose loved ones are incarcerated, and all of the work that you're doing to push up against the system is really what makes things possible. So I just want to really appreciate everyone and just start off by saying that. So thanks for being on with us tonight. I'm going to do a little bit of an overview of Clemency. So just some like nuts and bolts. What is Clemency? I'm going to give like some big picture stuff first, and then I'll jump into what are the components of filing a Clemency petition. So what are the nuts and bolts? What goes into the filing? What does it look like to file? And I'll talk a little bit about hearings before I'm done. And then Mira will come on and talk to you about what you may have heard about coming into effect just recently, which is the Joe Coleman Act, which is the same thing as compassionate release. In Illinois, we never used to have a compassionate release statute. So what that is to say, a specific way of filing for the release of someone who is either terminal or is very, very sick, or has disabilities that significantly impact their activities of daily living. And just recently, Illinois passed such a statute, and it was called the Joe Coleman Act. And it went into effect on January 1st. It was a huge success. We're grateful to everyone who worked on it. And so we thought that would be useful for everybody to hear about today as well. So I'm going to talk about clemency in the way that I just described, and then Mira is going to talk to us a little bit about the Joe Coleman Act. And you may find that the person that you're supporting, your loved one route may be more effective or more viable than the other. So we're going to talk about both of those today. And then because we have Ms. Daniels from the Prisoner Review Board, I have a couple pieces where I talk about a little bit what goes into strategy as far as filing. But since we have you with us tonight, I might pop it over and get your thoughts on various things, if you don't mind, Ms. Daniels. Thank you so much. But I'll do nuts and bolts first. So and thank you so much. Thanks for coming back with me. So clemency, what is clemency? I'm going to take you back to second grade civics lesson when we learned about the checks and balances in the system. I think it's helpful to have that big picture background when we try to wrap our minds around what is clemency and how it's different from a lot of things that you might file in court in ways that are really important when you support your loved one in filing, okay? So clemency is a power that comes from our Constitution, from the Illinois Constitution. And it's intended as a check, right? In light of this checks and balances concept that our whole government is based on. It's intended as a check on the judicial system. So the clemency power, which includes the power to change sentences, sits with the governor, right? And so the governor of Illinois is the head of our executive branch. And the purpose of clemency is to curb excesses of the legal system. So it's meant to be a check and balance on the legal system. So that matters because, first of all, when you do a clemency filing, you're not filing in court, right? And you're not litigating or relitigating a case. And we'll come back to that concept a little bit later, right? You're filing something with the executive branch, with the governor, through the Prisoner Review Board. And you're asking for something that in over 99% of cases is going to really be based on this concept of the 3 R's that we're going to come back to throughout the presentation, which is remorse, rehabilitation, and reentry. Remorse, rehabilitation, and reentry. That's going to be at the heart of your clemency petition. And I think it's helpful when you think through the nuts and bolts of that, which is what we'll get into as we talk through this today, to know why that's the case. And one of the reasons that is the case is because the power of clemency is vested in the executive branch as a check and balance. That's the concept. Whether we believe that or whether we think that's functioning as well as it should be is a different question. But that's the point. That's the purpose. That's the concept of that check and balance. It's supposed to be a check on the judicial system. Okay, so that's the power of clemency. I'm going to just say this briefly. This should matter less for the work that you're doing, but I'll be a little nerdy for just a minute. There's technically 3 types of clemency, and you'll hear about these. So I think it matters to sort of know what they are. Pardon, commutation, and reprieve, which is never used, but those are technically the 3 types of clemency. If your loved one is incarcerated and you're looking to change or shorten their sentence, you're looking for a commutation in most cases, right? You're looking for the sentence to be shortened so that your loved one can be released, right? We also have a pardon. A lot of people who are currently incarcerated think what they need is a pardon. In practice, the power of pardon in Illinois is almost exclusively used, almost only used for people who are no longer incarcerated and they're looking to clear their record, similar to like an expungement. So you get a pardon with permission to expunge, technically, is what you get. And that allows somebody to clear their record so that they can get a job or to get access to better housing or for some other purpose, right? So a pardon is typically sought by someone who is out and is looking to clear their record. When someone is currently incarcerated, typically what they're looking for is a commutation, which shortens their sentence, for example, to time served. Reprieve really isn't used, but it's just what it sounds like. So it's a temporary reprieve or break from a sentence. That's quite antiquated and we don't actually see it used, but technically there's 3 types of clemency. So that language comes from the Constitution itself. I actually grabbed it for us today, so I'll just throw it in the chat. You don't have to look at it, but if you're interested in it, you can see that language right there in the chat. So there's a bunch more rules about clemency that exist in what's called statute. And there's some guidance about clemency that exists from the rules that are put out by the Prisoner Review Board and the guidance that's put out by the Prisoner Review Board about what exactly you should file and how quickly those are processed. But the law, I should say the rule that comes from the Constitution is really just that short language that I shared there in the chat. So it's a pretty broad power. The governor in Illinois, and this is different state to state, but in Illinois, the governor has really broad and exclusive power to grant or deny clemency after receiving advice from the Prisoner Review Board. So let me talk about that for just a minute. The process for filing for clemency in Illinois. So when you file for clemency in Illinois, you file the petition, which is what we'll spend a bit more time talking about today, and all of the documentation that you want to share. And you file that petition and attached documentation with the Prisoner Review Board, on which Ms. Daniels, who's here with us tonight, is a member. And the Prisoner Review Board will accept and review your documentation, make sure that all the required elements are included. And if those elements are included, they will what's called docket the petition, which means that it's accepted for processing, and they'll give you a number. It's like a 5-digit number. And if you've requested a public hearing, they'll give you a hearing. And we'll talk about hearings later on in the evening. The Prisoner Review Board, after the hearing, if you have one, then sends their confidential, non-binding recommendation to the governor's office. So let's unpack that, right? So their confidential, non-binding recommendation means that nobody ever gets to know what that recommendation is. It's entirely confidential to everybody, right? To attorneys, to the incarcerated person, right? It's completely confidential, but it's also non-binding. So non-binding means that the governor can decide to essentially agree with the recommendation or decide the same thing. So for example, the PRB says we would recommend this person for a commutation, and the governor, in fact, commutes that person's sentence, or the Prisoner Review Board denies or says that they do not recommend this person for clemency, and the governor, in fact, denies that clemency petition, or the Prisoner Review Board can suggest that it's not granted, and the governor, in fact, grants it nonetheless. It's non-binding, right? So it's just a recommendation. It's a confidential, non-binding recommendation. Okay, so that's how it works in Illinois. It's different in every state. Not all states do that the same way. Some states have a very similar system. Some states have a very different system. In Illinois, the governor really has a lot of power to decide what they want to do with this advice from the Prisoner Review Board. So I'm going to talk about quarterly deadlines, and I'm going to move into the meat of the petition, but I'll just take a brief minute here in case Ms. Daniels has any additions or corrections to anything I've said so far.
No, you are on point. I really appreciated you adding that non-binding part, because I think that that's important, that people know that I mean, I guess they don't need to know, but it's just very important that the governor, to note that the governor has complete autonomy in his decision. Although we make recommendations, he can make a different decision. I think that's important.
Thank you. Yeah, thanks for saying. And I'm sure you'll have more thoughts for us when we talk about hearings and what you like to see.
Yeah, as we go forward. But so far, you're on point.
Cool.
It's great information.
All right, so let me just mention this quarterly deadlines process, and then I'll talk about the meat of what goes into a filing. Yeah, so the way that it typically works, except for a period of time during COVID, which is now over, so we're back to this system. The way that it typically works is that the clemency process is on a quarterly deadline system. And what that means is that the vast majority of petitions that are filed, you file for this quarterly deadline. So in other words, there's 4 per year. And the deadline is just a deadline for the next hearing dates, right? So it's nobody has a clemency deadline if you've done like post-conviction, or if your loved one has talked to you about post-conviction deadlines. There's no deadline like that with the clemency. There's no one deadline that somebody has to file by, right? The deadline is a quarterly deadline system, and that date gives you a hearing in the next set of hearings. So for example, there was a clemency filing deadline for January, I believe it was 25th. And if you filed by that January 25th date, you got a hearing date in April. And there's a reserved week in April. So you know in advance, at least the week that it's going to be. And then after you file, they'll tell you the exact date on which your loved one's case will be called. So we'll talk a little bit more about hearings. I'm going to do that last. But as part of this, like thinking about the structure of what goes, big picture, what goes into this, right? You're talking about filing a petition with documentation. There's a quarterly deadline system, and maybe Mira will share, actually, if you could share the Illinois Prisoner Review Board's website has in advance that quarterly system. So you can look when the next deadline is, when the next hearings are, et cetera. So you can kind of have like a target date maybe that you're going for. It's all sort of set in advance. One important thing though I want to say about that before we move on in terms of big picture, take note, in general, the hearing dates happen either in Chicago or in Springfield. And your family may be able to travel to either, but depending on who all you want to go with you to appear, and we'll talk more about witnesses and that stuff later on, you may find that it's preferable for your family to have the hearing in Chicago or to have the hearing in Springfield, especially if folks have kids or if folks have difficulties traveling, if transportation is an issue. You may want to plan around being able to appear in one location or another to make sure that everybody in the family can come, okay? Sometimes they go back and forth. Sometimes they may do 2 in Chicago or 2 in Springfield in a row. So just pay attention. That's listed way in advance. So you'll know the location, you'll know the week. You just won't know the exact date until after you file. So let me, yeah, go ahead.
Can I step in just real quick?
Absolutely.
Those are scheduled, those locations are, January is always in Springfield, and the remaining 3, April, July, and October, are in Chicago. And then if something changes, you will be notified well in advance, but that's typically the order.
Thank you. That's really helpful. Deonta, I see your hand up. If you want to give your question, I think we're mostly going to wait for questions to the end, but if it's a quick one, we could grab it now.
That was a mistake. That was a mistake. Sorry.
Oh, no worries. No worries. I'm happy. I'm happy you're on. Yeah, Angie, you had a question. No, okay, cool. I'm also learning how to do the hand raise function, so no worries, everybody. So let me talk about what goes into the petition. I want to say a couple things about this. On our website, which maybe Mira will also helpfully share with us. Thanks for the other one that you shared, Mira. On our website for Illinois Prison Project, we have a template that you can fill out. So I'm going to take you through sort of big picture on what goes into a clemency. But if you're going to be doing this for a loved one, I highly, highly recommend that you check out our template and look at all the details of what's included. A couple things I want to say about it. I touched on this earlier. One thing to know about clemency, right, is that you're not filing something in a court of law. You're not relitigating the case. So one of the questions that we get a lot, right, when we talk on, for example, our legal clinics that we have twice a month is, there's a lot of things that went wrong with my loved one's case. There were errors made by the attorneys. There were errors made by the judges. There were prejudices, et cetera, right? And we as attorneys at IPP, at least, we totally believe that all those things happened. But clemency, in I would say nearly 100% of cases, is not the forum to be making those arguments, right? Clemency is about remorse, rehabilitation, and reentry, right? So you want to be really, really careful about picking your battles in the context of clemency. You want to be really careful about picking your battles, especially issues about what an attorney did wrong, what a judge did wrong. These kinds of issues are generally, it's not the right forum to be arguing about those in your clemency petition. What should you talk about in your clemency petition? I talked about rehabilitation, right? Rehabilitation is, we believe at IPP, and I think everybody on this call believes this, nobody is defined by their worst mistake. We want to know about the whole person that your loved one is. We want to know about everything that they've done during their incarceration. We want to know about their schooling. We want to know about their jobs. We want to know about, even if I know that there's a lot of restrictions on things that particularly people with long sentences are allowed to do while they're incarcerated, but there may be things that your loved one did informally. Were they a mentor to other people who are incarcerated? Are they an artist? Do they do poetry? Do they do artwork? Do they do creative story writing? Do they do other types of things that perhaps could be captured in letters of support from other incarcerated people, examples of artwork or poetry, examples of other things they've been engaged in that maybe isn't formal, but are things that they've been involved in that somebody can attest to just informally with a letter, or that can be documented in some other way. That should be the heart of your petition, that rehabilitation with as much documentation as you can possibly get. So that includes certifications. You absolutely want those if someone's gotten a GED, gotten an associate's degree, if they've been involved in mental health groups. So for example, anger management, those can also be included there as part of rehabilitation. Another key part of your clemency petition is reentry. It's really critical, and I think Ms. Daniels will talk about this maybe in a minute here if you want to add to this. It's really critical that your clemency petition has a strong plan for what will happen if your loved one is granted clemency. And that includes where they're going to live. And it also includes how they're going to have other types of support that they might need. So for example, even if someone has been sober for decades, which is true for a lot of incarcerated people, even if they had needs around substance use before they were incarcerated, the transition out of prison, as exciting as it is, can also be really, really difficult. So what is that plan to maintain that recovery? Who is that person that they're going to call after they get out? And things are just hard and stressful, because they absolutely will be. So plans around the just in case plans, right? You're going to have the definite plans, which is like where they're going to stay, who's going to help put their resume together, who's going to teach them how to use a cell phone, who's going to buy them a cell phone. And then you're going to have the just in case pieces, right? So who's going to be that support if they do need mental health support? Who's going to be that support if they do need substance use support? really robust reentry plan with specific ideas about who's going to do that, attached letters from family members and organizations, ideas of organizations that they can go to if they need that, if they're a person of faith, where they're going to be going to practice their faith or who they're going to be doing that with, are all part of the reentry plan. Ms. Daniels, you have a lot of expertise in this area. I wondered if you had thoughts.
I think you really did cover it in simply stressing the importance of a solid reentry plan. Some of the best, for lack of a better phrase, the best petitions that get the most consideration are those that have a solid reentry plan. And of course, we're talking about those individuals who are incarcerated and seeking reentry versus those who are already who are just simply seeking a pardon and expungement. And there needs to be a holistic plan in place. Again, we want to know that you have confirmed a place to reside. If a family member is saying that you can come there or that they have a place set aside for you, they need to be present to confirm that. And there needs to be letters of support from individuals who are offering to support financially. If there's a job opportunity that is available for the petitioner, that needs to be stated. That is something also we want to know how you're going to support yourself financially. That is extremely important. Letters that say, you know, our family has a robust savings that we've put together for our loved one are always very, very helpful. We want to know how you are going to if there are medical issues. A lot of times individuals who are incarcerated for long periods of time for long-term sentences often come home with medical issues that have been unaddressed. We want to know that you qualify for some sort of supplemental insurance or some form of Medicaid or Medicare or something of that nature. And so information confirming all of that is extremely important. Rachel also mentioned, you know, if you have a faith community, we want to know. I'm thinking of, you know, individuals who we've gotten letters from the head of the church saying we're here to support this person, and we have, you know, these systems in place where we will be there just in case person, or we have a team set aside. So there's an entire system that is needed for successful reentry, particularly for someone who has been has served a long-term sentence. It is vital for the successful transition for someone to have a holistic and solid support system in place, and it makes a very, very big difference in how decisions are made when that information is available.
Thank you so much. And I do see the Prisoner Review Board, Ms. Daniels, included asking family members questions about this topic, even when we're going to talk about the hearings more in a second. So it really is just, again, to underscore such an important piece of the petition. And I think we underscore it also because we often see people miss that or not put quite as much attention into that as maybe would be helpful. Okay, the last thing I want to touch on again, right, the 3 R's that we think about it this way at Illinois Prison Project of a clemency petition: remorse, rehabilitation, and reentry. Remorse, I want to talk about that for a minute. So that means it means a couple of things, right? So again, clemency is not in most cases the place where it is most effective to be claiming innocence or to be emphasizing your lack of responsibility in a case. There's exceptions to that. And I think in every case, it's helpful to talk about the context and maybe some of the reasons why something happened the way that it did. But there's a big difference between talking about the context or the reasons why something happened and giving excuses for why something happened, right? So in the clemency context, there is a question, there's a part of the petition that asks you to give what they call the petitioner's version of the offense, which means tell the story from your point of view, from your loved one's point of view who's incarcerated. It's really important that what you explain in that section is as honest and straightforward as you can possibly be. It's not helpful for people in this context to minimize their own involvement. And that can be really counterintuitive for a lot of reasons that make a lot of sense, right? We have this entire legal system that's set up around this idea that we're going to have a battle about something, and there's this group called the prosecutors that are going to try to prove that someone is guilty in this legal way that we've created. And so it can be really counterintuitive for people to stop 15, 20 years into their sentence and say, actually, I take responsibility for these components of what happened. But if that is true, and I think that's true for a lot of people who absolutely deserve for clemency to be granted, it can be really helpful just to name that, to name your loved ones take responsibility for as much as they can, and be really honest and clear about what they do take responsibility for. And you can do that in the text that you maybe are helping to type up. You can also, we often have people include a handwritten note that explains a little bit, provides an apology and explains a little bit about their own feelings of remorse, particularly toward the victim's family, towards any survivors in the case. I find that really helpful. I'm curious, Ms. Daniels, if you all find that helpful.
Yes, it makes a big difference. When I do petitions, when I review petitions for my own presentation, one of the things that always stands out for me is when I can say in my personal notes where we're talking about the petitioner's version, I can say that the petitioner's version differs very little from the state's attorney's account, which means he's taking full accountability, and the petitioner acknowledges his or her role in the event. Because they're positioning themselves to be held accountable for what they did, and that makes a big difference. Do the circumstances vary from time to time? Of course they do. And again, I mean, I've been doing this for almost 4 years now, and so I've seen hundreds of petitions. But again, the ones that stand out for me and move a little more fluidly for me in my decision-making process is when the petitioner is owning it, is owning it throughout the process of his petition, his or her petition.
That's really helpful.
Yeah,
that's really helpful.
Excuses. Yeah, not making excuses, but I'm just saying, this is where I was at that time. This is who I was at that time, and this is what happened. This was my experience at that time. Here I am today, 10 years, 20 years, 30 years, 40 years later, and this is who I am today. And it's much easier to go from here to there when there aren't all of these variables that include what really had happened was when we don't have all of that. And that doesn't mean that there are completely different circumstances. That doesn't mean that there are circumstances that actually existed that are completely different or vary from the state's attorney's statement of facts. But for most accounts, the individual who was incarcerated had, and is explaining their role is makes the process a little more fluid.
Yeah, that's really helpful. And the way that works in my head as I'm working on a petition for the board and the governor, is I really, really think about picking my battles, because like Ms. Daniel said, there's going to be things that are different between the police account and the state's account. And I really just over and over again, as I'm working a petition, ask myself, but is that really sort of the point, right? Or is my point that the person that I'm working with takes responsibility for this part of what happened and is a different person now 20 years ago? And that's what I want to describe. That's what I want the board and the governor to know about the person that I'm working with. So, okay, let me talk about hearings for a minute, because I know we have a lot to cover for tonight, and then maybe we'll pass it over to Mira after this. So hearings, I have a couple nuts and bolts to talk to you about hearings. So your loved one, as the person filing, has a right to request a public hearing. And the public hearings, as we said, are in front of the Prisoner Review Board 4 times a year. And when you make that request in your initial filing, and you just do it there's nothing fancy to it. You just say, I request a public hearing. You can have, technically it's up to 4 witnesses appear in the public hearing. Your loved one, the incarcerated person who's filing, does not have a right to appear in their own hearing. So they will not be attending. Okay. You can attend and should attend as the family member. I find it really helpful in particular to have, if there's a family member who is housing the person, I find it really helpful to have them attend. Other people that are doing a lot of this sort of reentry support that Ms. Daniels and I were talking about, they should be attending the hearing. You can have up to 4. 4 is not necessarily better. Those hearings go really, really fast. Every hearing has there's no like set amount of time that the hearing has, but I think they run about 10 to 20 minutes total. And that includes, that's not just you talking, right? That's you talking for a couple minutes. And then the board, the prisoner review board, asking questions of you and your other family members and witnesses, right? So it goes very, very, very fast. So sometimes having less witnesses, sometimes people try to hit that 4-person mark just to hit it. And what that means is that people have less time to talk. So you may have 4, that's great. You can have up to 4, but be thoughtful about that number. I'm curious what Ms. Daniels thinks about this. I tend to tell people, don't read a prepared statement. If you have a prepared statement like a letter, that should get filed. That's great. And it should get filed with your clemency petition. But when you're appearing in front of the board, you don't have to read something that you already filed. You want to be available to more so ask questions. So I don't know, Ms. Daniels, if you have thoughts about that part.
Yeah, that's a place where we often have, I don't want to say issue, but it comes up, I'll say that. Yeah, we want to talk to you. We want to hear from you. And if there's a written statement, then put it in the file, as Rachel said, and let us read it. Or we've already read it. If it's in the file, then trust that we've already read it, because we go through all of the documentation prior to the hearings. And so what I'd like to think about the public hearing as an opportunity to humanize the individual who is seeking clemency as best we can. And if that individual is incarcerated and he or she has family members representing them there, then you are the face of that individual. And we want to talk to you. We want to have conversations with you. And we don't want to talk about what's in the petition, because we've read everything that's in the petition. We don't want to talk about what happened that day. We don't want to replay all of the versions of the event. We just want to talk to you. I mean, there may be questions, but the questions more often than not revolve around what reentry is going to look like if your loved one is granted clemency, and you giving us an opportunity to see, make a human connection with that individual. That's what we're looking for. And it just works. It feels so much better if we're just having a conversation versus you holding your head down and reading a prepared statement. Let's talk about it. Yeah. I hope that helps.
That's very helpful. Yeah, that's very helpful. And it can be hard to do, right? So I want you to really hear it from Ms. Daniels, who's one of the members that folks present to, that it often makes people feel better to have that statement in front of you, but they really want to, as she was explaining, right, hear from you, right, and have it as a conversation rather than that prepared statement. So it's hard to do, but I do think that it's better if you can kind of let go a little bit that security blanket.
And I would just add, we get a lot, oh my God, I'm so nervous. And of course you're nervous. You're fighting for the life of your loved one. You that's on the line, and it's the most important thing that you could possibly be doing on that day at that time. And we as board members are people too. And you'd be surprised at, how accommodating and comforting many of us have a tendency to be when you're in front of us. We just want to hear from you. We know it's hard. We know it's nerve wracking. And you've been preparing for this with all your paperwork and all your making sure all your I's are dotted and your T's are crossed, and all your filings and meeting your deadlines, and then you got to get downtown, or you got to get to Springfield, and then you get there and then you're waiting, and then they call your name, and then oh my God. And so there's this big buildup and sometimes we get people to come and sit and sometimes they can't even speak. All they can do is cry because they just want their loved ones home. And so we understand that. We really do understand that. And it is our effort. I gotta speak for Lisa Daniels because we have a really great group of people. We really, really do have a great group of people. And but I know it's always my effort to simply humanize your loved one. I've read a lot of paper, I've read their experience on paper, and now I want to see who loves them and why they matter, and why do you want them home, and what will it mean for your family to have them home. I want to have that conversation. I want to have that conversation.
Yeah. And often I think what that looks like is not having like some perfect word or some like very clear sentence, right? It's you. Like what you need to do at the hearing is be you. And that's a really hard thing to do. My job is a lot easier, right? Because I get to show up as the attorney with all this like prepared, stuff, right? The harder job is to show up and just be you, but that's the job, right? It's to show up and to be you, right? Not to have like some perfect word that's going to open the door, right? To show the love that you bring just by your presence. So the last thing I'll say about that, and then maybe I'll kick it over to Mira, is that because of that, but also because the hearing is so short, and because by way of reminder, right, what happens at the end of the hearing is nothing for you on your end, right? So what happens at the end of the hearing, right, is that Ms. Daniels and her colleagues go back and talk about your case, and you're not there, right? And that's per the statute. That's what they're required to do, right? But you are going to Ms. Daniels is going to say, thank you very much for your time. And you're going to walk out of that room, and you're not going to know what that recommendation is because it's confidential by law, right? And there's also no timeline for when the governor, who again is the ultimate decision maker, is going to get back to you. And so the last thing I want to say about the hearings before I pass it over to Mira is one of your jobs as the family member for an incarcerated loved one is not just to support your loved one through the filing process, which is hard in a certain kind of way because it's this hurry up and file, get all this stuff in here. But there's something nice about that because you have something you can be doing. And what's really, really hard for people is after the hearing is over, the job is to wait and wait and wait and wait and wait and wait. And that can be really, really, really difficult. So as you come out of that hearing, it's going to feel unsatisfying. You're never going to come out of that hearing feeling like, it's because it's impossible to represent all of this human that your loved one is in 2.5 minutes while you're sobbing. It's never going to happen. You're going to walk out of that hearing and you're going to feel unsatisfied, and you're going to feel like you didn't quite do it all. And that's just what everybody feels like. And then you guys are going to wait possibly for over a year to hear anything from the governor's office. And your job as the loved one is to support and keep your loved one's hope alive through that waiting period. Okay, so I say that just to prepare, to give you the power of being prepared for that and not to discourage you, but because that time can be harder than the filing time, and people aren't always prepared for that to happen. So I will close it there unless Ms. Daniels, you want to say more about any of that.
No, you hit the nail right on the head, and it just, I think what I thought about it, and it was amusing to hear you say it the way you said it, but it's not funny at all to see the families, when they come and again, that build up, they've traveled, they've gotten on planes, and then they come and then they get their name called and they sit and they pour out for 2.5 minutes or 20 minutes. And then we go, all right, thank you. And that's it. That's it. And, but that's the way it happens. And unfortunately, that's the process. Yeah, that's the process.
Thank you, Rachel, and for Lisa too. And I love how you're kind of having Lisa jump in here and there. That's like really super informative. So we're going to turn it over to Mira DeJong, who is a staff attorney with the Illinois Prison Project, and we'll put her bio up here so you can read it while she gets started, if that works. Hopefully the slide will come up or not. And Mira can just start wherever she is.
Okay. Yeah, I'll just start.
I will grab it and throw it up. Oh, there we go. Okay.
There it is. Okay, thanks.
Okay. Yeah, after a few minutes, take it down so I don't have to see
Yeah,
it.
just this way people could read though, and I don't have to read all about you, right? You can
Yeah,
go.
I appreciate that. Okay, yeah, so I wanted to talk a little bit about something that's new in Illinois, which is our compassionate release statute. So as of January 1, we have this new law that's called the Joe Coleman Medical Release Act. And what this does is that it creates a quicker pathway out of prison for people who are terminally ill, who are medically incapacitated, or who are likely to become medically incapacitated within the next 6 months. So terminal illness, that's simple enough to understand. It's defined as likely to die within 18 months, I believe. And then medically incapacitated is defined as that the person has a medical condition that requires them to need help with with I think 2 or more activities of daily living. Or maybe Miss Daniels, do you know off the top of your head? I can check the statute also. This is my bad, but basically
No, you had it.
How
You had
much?
it, Mira.
It was
Is it
okay.
2 or more?
Okay, I'm sorry.
Yeah. Yeah. So basically that someone needs help with things like bathing, dressing, mobility. Yeah, there's specific definitions of what an activity of daily living is, but it's those sorts of things. Or else that they are that their medical condition disables them to the point that prison does not create any additional restrictions. And I can't tell you exactly what that means because I don't think we know yet. But yeah, actually, Miss Daniels, do you want to weigh in?
Yeah, I can. We actually had our first set of hearings today, and yeah, we did. And we were relieved to know that both petitioners were granted relief today.
Good.
And that's not a confidential recommendation. That is a standing. That's an order now. They
Wow.
have both been granted relief. There being the proof that they're ill. I mean, the statement that their illness does not afford them any more restrictions. What that means is that they are no more confined, being incarcerated with the illnesses that that person possesses than they would be incarcerated without those illnesses. Does that make sense? Meaning, if they go home with the limitations and of their illness, the incapacitation that they are experiencing, they are no more a threat to the community than they would be if they were still incarcerated. So being incarcerated offers no more restriction for them. They are restricted by their bodies. And the community is no less safe with them being out of ideal-C custody because of the physical restrictions that they have because with the physical restrictions that they currently experience in their bodies as a result of the illnesses that they have. Does that help?
Yeah, that's super helpful for me. Thank you. Okay, yeah. So that is those are the ways that you can qualify for relief under this new law. So similar to a clemency petition, your Joe Coleman medical release application is filed with the PRB. However, the final decision is getting made by a 3-member panel of the PRB rather than the final decision being made by the governor. And also different from clemency is that with a medical release application, you're going to get a decision within 90 days of filing, as opposed to a clemency, which there's no deadline for when you have to get a decision. The governor's office can take as long as they want to take with it. Also similar to clemency, you have a right to a public hearing for these medical release applications. And also you have a right to have 4 witnesses show up. The person who the application is being made on behalf of does not have a right to be there. And then I believe that also the prosecutor and any victims also have an opportunity to speak at the hearing. Is that correct, Ms. Daniels? Okay. Yeah, and I say I believe because we haven't done these hearings yet because this is so new, and our office is going to be doing our first Joe Coleman hearings next month. So we'll know more after we do that. So the public hearing, you can. Oh, did you want to weigh in?
I just wanted to add that might sound contradicting to what I just said, that you're doing your hearings next month, but the hearings that we did today were not public. So
Yeah.
I just wanted to make that clear so that there's no confusion for the audience.
Yeah, yeah, that's a really good point. So you can waive your right to a public hearing. And if you do that, then there's going to be a private hearing where it's just the PRB deliberating. And what we think, and what Ms. Daniels, you seem to be confirming, is that an application might move faster if you waive the public hearing. It might not take the full 90 days then. But that's, kind of a decision that you and your loved one will need to make, of whether you want to waive that hearing or whether you think that the hearing is really important and that you have, things that you need to get across there. Yeah. So again, I think that's a decision that you will have to make. And I don't know yet, what those hearings will look like.
Yeah, they should be
Yeah.
interesting because the way that it went today, there was more than enough information there to
Mhm.
say that these individuals deserve to be released. One individual has a life expectation that does not exceed the next 6 months, and there was nothing that could have been added to make to make a different decision for us. We were clear that that these individuals deserve to die. This individual deserved to be at home with his family and loved ones, and die with the most amount of dignity that he could have. So, yeah.
Yeah, it's really heartening to hear that those two were granted and to know that that's going through and that it's working as it was supposed to, that people are not going to have to die behind bars. Okay, one other thing that is different from the standard clemency process is that there's no quarterly schedule. So there's no quarterly deadline. The hearings are just scheduled as the cases are filed. It's a rolling docket. And that makes sense, right? Because the whole purpose of this new law is for people to be able to get out of prison quickly if they are dying or if they're really seriously ill, and so that they can spend their final days at home with the people who love them. Okay, now what actually goes into this medical release application? There is a form that's on the Prisoner Review Board's website that you have to fill out and you have to submit. So there is, that's on the PRB's website, but I'm going to post a link right now to our medical release handbook that we wrote up as an organization. And there is a link to the PRB form in there. But okay, so on that form, you have to give some basic biographic information about the underlying conviction. So similar to what Rachel was saying before, you have to give, the petitioner's version of what happened, some of that reentry information, where is this person going to live? And then also you have to check a box saying, why does this person qualify for relief? Are they terminally ill? Are they medically incapacitated? Or are they likely to become medically incapacitated in the next 6 months? So this is, that's the information that you are required to give on the form, but we strongly suggest that you also prepare a petition to submit with your application. And that petition, as far as we're writing them, looks similar to a clemency petition, maybe a little less detailed, but similar. So we suggest that you write a personal history section so that the PRB can see, who your loved one is as a full human, to know where they came from, what the context was for, whatever led to them being convicted and incarcerated. And then to also include a rehabilitation section where you talk about what your loved one has been doing while they've been incarcerated. But then what is really different from or what we would suggest you do that is different from a traditional clemency petition is that you're going to get, really into the weeds about what this medical condition is and when the person was diagnosed, what their symptoms are like, what the prognosis is, just really clearly making the case that your loved one qualifies under this statute. And then you also want to provide medical records to back up those claims. If your loved one is medically incapacitated, then you want to describe what's their current condition, what kind of help are they getting on a day-to-day basis. Do they get help with bathing? Do they use a wheelchair for mobility? Do they live in the healthcare unit full-time? Do they have a lower bunk pass or a lower gallery pass? Those sorts of things. So yeah, providing as much info as possible to show that your loved one qualifies, and then providing whatever medical records you can to back up those claims. And then also, just like Rachel was saying before, talk about the reentry plan. So if your loved one gets out, where are they going to live? If they are in a wheelchair, is that home ADA accessible? Who's going to take them to and from their medical appointments? Where are they going to go for medical care? If your loved one has cancer, is there a hospital nearby that can provide them with the care that they need? So just as robust of a reentry plan as possible, but with, I think, a special eye towards medical care and who's going to help them get that, and what kind of insurance they might qualify for, benefits. But yeah, I don't know, Ms. Daniels, if that sounds right to you, or if that's as important as a standard clemency or less so.
The reentry piece?
Yeah.
Oh my God, yes, it's absolutely is as important. Yeah, because what are we doing? Are we sending this person from a bad situation to a worse situation, or a worse situation to an even worse situation? So yeah, it is very, very important. Both of the individuals that we saw today had very solid reentry plans. One had a family member who had a home, had his own home. It was a brother, and was, prepared to bring the individual home with all of the resources that are necessary. He had a home health aide lined up, and all of the things that need to come in on a weekly basis and take care of all the things that needed to be taken care of. He actually expressed that he had, this individual had, among the medical issues, this individual has dementia. And the family member provided information that stated that he was qualified to care for him because of work that he had done previously. So all of that information is absolutely important to make the consideration, because we don't want the person to come home to even more substandard, if there could even be such a thing as medical care as than what they were receiving while they're in IDSC custody. We want them to be able to, and I'm sure as a family member, you want them to be able to have the best care. So absolutely, it makes a big difference.
Yeah. And I know that there's a field on the PRB application that says, do you want help finding a placement? Or if there's nowhere to go, do you want help finding a placement? And I don't know if that has come into play yet. I'm curious to see how that's gonna function.
Yeah, I am too. I am too, but we have not. We just did the first two today, and both of those petitioners were represented by attorneys, and they had very, very solid petitions put together, and they both had very solid reentry plans in place. So I have not seen yet what that would look like, where there are support services or assistance with support services, and how that would play itself out.
Okay. Yeah, I'm really curious to see how that plays out. Yeah. Okay. So then along with the PRB application and the petition that you write, you should also be including all of those supporting documents that Rachel talked about before, letters of support, certificates, medical records, like I said before, anything that is just substantiating your claims. In terms of getting medical records, your loved one should be able to get those directly from the prison. That's probably going to be easier than you trying to get their medical records for them, because that's going to require a release form and it's just going to be tricky. So, I mean, it's always tricky getting medical records. So we think it's probably easier for your loved one to get it directly. If they have gotten care at an outside hospital, if your loved one has been getting chemotherapy at an outside facility, it's probably a good idea to request those records as well. And you will need a release form from that outside hospital. So then once you have your form filled out, your petition written, all of your attachments pulled together, then you're going to file the application with the PRB, either by email, by fax, or by snail mail. And then you're waiting for a docketing letter, which is going to tell you the date of the hearing and the docket number. And then from there, you have the hearing, and then you are just waiting for a decision. And that is going to come within 90 days of when the application was first filed. And if the application is denied, you are required to wait 6 months before you can file again. Although there is supposed to be a mechanism where I think if someone is truly, on death's door, there's supposed to be a way that they can bypass that 6-month waiting period. But again, I think this is also new, that we haven't really yet seen how that's going to work. Yeah, I don't know, Ms. Daniels, if you have anything to add to that, or if that's probably just a wait and see, because it's probably too soon for anything to even have been denied yet. So. Okay, I think that is basically all that I had to say about that, but I'm really glad that this exists now, and I'm hopeful that a lot more people are going to be reunited with their loved ones, so that they can die with dignity or take care of really serious diseases from the comfort of their own home. And not have to face the inhumanity of trying to manage something behind bars.
It's really good to hear that there might be a little bit of mercy shown in this whole thing. So that is good. Mira, is there anything else, or should we?
I think that's it from me. Yeah.
Thank you. And well, Lisa, I know they've kind of been kind of going at you. Lisa, besides being an advocate, she's a friend of mine and just an amazing person, really. We're going to put her bio up there, and I'm hoping, and I'm sure a lot of the people on the Zoom right now are hoping you can give them maybe some little insider info on, although you have shared a lot, if there's anything else you can share.
You gotta help me out, Julie. Share about. Am I sharing? What am I sharing?
No, just what they should really strive to find, to put in their petitions.
Mm-hmm.
Again, I know it's just you, and everyone probably on the board looks for maybe different things, but what often strikes you and what maybe would be a turnoff or something. I don't know if there's any insight.
Sure. I no worries. I can answer, I can look at a couple of things, or I can touch on a couple of things, and then I guess we can just answer questions. I saw lots of questions come up in the chat. Jacqueline asked a question that I saw. She said, can a letter of support be too long? Because I could go on and on and on. And I say to that, I get it. Everyone wants their loved one to come home. Everyone and everyone could say lots and lots and lots and lots and lots about who their loved one is and why they want them to come home. But I would say short and sweet is probably best, straight and to the point. And the reason I say that is because you don't want your message to get lost in the hundreds of of letters of support that we get and receive from families just like you that love their loved ones just as much as you do and want them to come home just as much as you want yours. You want us to hear your message. And so I think that a clear, succinct letter would be beneficial. But then here's the thing: when you come to the hearing, that's that human piece that I was talking about earlier. Tell me all about it. Tell me as much as you want to tell me there. But when you write the letter, you don't want it lost on all of us. So, make it short and sweet, and then talk to us when you come to the hearing. So
I have a question.
sure, Julie.
Which I'm going to throw out there. I think that Rachel had touched on the fact that hearings are optional, right?
Public hearings are
Public
optional.
hearings are, so everyone gets a hearing? Some of them are private, is that it, or?
Yes, some can request a non-public hearing.
But everyone gets a hearing then? See, I don't think I knew that. I didn't know if you just read some of them and put them on through.
I don't know.
Okay.
Yeah, no, the petition to ask is a right. The only way that it doesn't get put through is if there's something missing in the application. If the application isn't completed to the way it's supposed to be completed, then it goes back for you to resubmit it. I believe, because I don't work on that end. That's the office and the administrative component in the office, and they would be excellent if you guys ever do this again. Someone from the office, Kelly Kaepernick. No, that's not Colin Kaepernick. Kelly, I can't think of Netmeyer. I think is her last name. Kelly Netmeyer.
Okay.
Yeah, and there's another young lady. Melissa's no longer with us, but there's another young lady that is working in, and then Nicole Damhoff also. They would be able to answer the administrative questions about the filing and that whole docket process and all of that. Those would be the ladies to answer those questions for you guys.
That's interesting because I didn't know when they said you could request a public hearing that if you don't request it, then your hearing is private.
Yeah, it's all non-public. Yeah, but yeah,
non-public. I don't mean
non-public, which means that we as a board, we just meet and no one is there to speak on behalf of the petitioner. We read the petition, we have a deliberation, and we make the decision, or not the decision, but the recommendation.
So the family's not there either.
Right, the family's not there, but it's because they requested it. Yeah.
Now, do you think that's a better way to go, or no? It's much better to ask.
I think it's better. It goes faster for us, but it leaves a human component out for us. We don't get to make a connection with the family or the petitioner.
Okay.
Yeah, and it's amazing to me. I mean, I know all of the circumstances are different. I know that there are hundreds and thousands of variables in each and every one of these cases, but it is interesting to me as to why someone, or I say it's lost on me, as to why someone would request a non-public hearing, but I'm sure that there are reasons. It means that you are Margot says, okay, public just means you are there to be questioned by the board. Is that what she said? No,
yeah.
Not just private means you're not. Yeah, but not so much that you're there to be questioned by the board, Margie, but that you get an opportunity to speak on behalf of your loved one. That's what's most important, I think, to take away from that. And yeah, we do ask questions, but that's not why there's a public hearing. The public hearing is for you to speak on behalf, and if you have attorney representation, for the attorney to present your loved one as well.
Oh.
Is it helpful? No.
Thank you. That's good to know.
No,
right?
I mean,
that was helpful.
Yeah, I mean, it's cute for optics. when people have, I mean, and I've seen it, where they've got, 10, 12 people with t-shirts on, and it's cute, but and so what it says to us is, wow, that person has a lot of people that love and care for them. But
would letters say the same thing then if you had a stack of letters similarly? I mean, you'd say, okay.
wow, they have a lot of people that love and care for them.
And
Yeah.
you read all the letters? I mean, it seems like there'd be a lot of letters. So I would say you speed read them, huh? No? I mean, come on.
Let's say speed read them. Let's say speed read them.
What we call that the cone of silence.
Let's say speed read them. I thought you can only have 4 present. No, you can only have 4 speaking on your behalf. There's envision a courtroom. And so you've got the room, the seats behind the little gate where people come and sit and testify. And so that's where all your supporters in the t-shirts can sit. And then the people that come to the table and actually speak to the board are capped at 4. Suzanne asked, in a non-public hearing, does the state's attorney comment, and is the petitioner provided with a copy of the comment? Yes and no. Yes, the state's attorney does still speak on behalf of the state's attorney's office, but the petitioner is not provided with a copy of the comment. Oh, wait a minute. Does the petitioner get a letter of the state's attorney?
We have to request it.
Okay, all right. Thank you.
Yeah, we have to request it.
Okay.
Yeah, that's exactly right. I actually did a follow-up about that, Ms. Daniels. Do you know, for the non-public hearings, it sounds like the state's attorney can appear if they want to.
Yeah.
Can members of the victim's family also appear at those hearings?
At the non-public hearings? No.
Got
No,
it.
because it's a non-public hearing. Yeah, no.
Okay.
However, they can provide protest letters that go in the file, so their voices do still get heard. Should letters of remorse be typed or handwritten? It doesn't matter.
See, there you go. And it said, can petitions be, I think it should be refiled if someone submits something and then realizes they did it incorrectly.
If someone submits something and they've done it incorrectly, it's gonna come back to them anyway for resubmission, for correction and for resubmission.
And I'll add just a bit to that, if you don't mind, Ms. Daniels.
Sure.
And if it's not rejected, so it may be rejected, for example, if some of what's required by the PRB isn't in there.
Yes.
But if you're like, if you're thinking, oh, there's 3 more certifications that I wanted to attach, obviously the board won't know that. And so one thing you may want to consider is this: when the petition is pending, you can't file another petition, but you can file a supplement. If the prisoner review board has already made their confidential, non-binding recommendation, they can't consider your supplement anymore because they're done with your case, right? But they can forward it to the governor's office, and then it's totally up to the governor if the governor wants to consider it or not. I would encourage you to file what I call late supplements, even though the prisoner review board can't consider them. For example, one reason you might do this is your loved one had been working on their master's degree when they were filing, but they got their master's degree. So you could update with that. So big updates, right? I often see people update when their loved one maybe was sick and got a lot sicker, or was diagnosed for the first time with a medical condition. Those are things if it's a severe medical condition, those are things I always do a late update on, right? So not small updates, but if they're major updates, that's when I would do a supplement.
Felicia's got a very good question.
Yeah.
This is excellent, you guys. This is so great. I'm so glad you guys are doing this. Do you want to respond?
Yeah, if the purpose isn't to relitigate the case, then what would the state present in the hearing? Because we know many of us are familiar with court, and we know that the state likes to always relitigate the case.
Right.
So that is a good question.
Yeah.
Rachel, anybody?
Sure. So I think at Illinois Prison Project, our position is that they are focusing on the wrong things. And that in a clemency hearing, the focus should be on the rehabilitation that your loved one has been engaged in, and it shouldn't be focused on solely on what happened in the past. A reason that they may raise this, and this is why it's really important with what Ms. Daniels and I were both saying earlier, that she said something like, I look for being able to tell my colleagues that the petitioner's version of the offense doesn't differ substantially. I think that's the language she used, from the state's version, right? So if your loved one's version does differ substantially, if your version of the case is totally different from what the state's attorney's position on the case is, that's going to raise a giant question mark. And that is something that I would guess would be a flag for the Prison Review Board and the governor, right, when they're looking at it. So if it's small differences, not a big deal. But if there's big differences, that would be a reason why they would raise that. I don't know, Ms. Danz, if you stuff to add.
I would also add to in as far as what the state presents. They present opposition more often than not. The state is there to present their opposition to the request of the petitioner, and they usually come with a very detailed outline as to why they are opposing, or why they believe why they are opposing the petitioner's request for clemency. Oftentimes it could be because they just feel like it was a heinous crime, and that granting a clemency is an extension of grace, and this person has not met the criteria, or that this person, another thing that I see often in state opposition letters is that the person has not exhausted all other options for early release, or for what am I trying to say? For having their case, maybe they haven't exhausted all of their appeals. And so they come in with guns blazing, 9 times out of 10, with their opposition and their rationale as to why they don't think that this person is, this person's petition should be considered. And then there are those times when they come in and they say the state has no opposition. They believe that, they won't, I've not seen where they would extend any more rationale. We believe that this person has done a bang up job, and we are in agreement. That's not going to happen. But they will come in and say the state has no opposition. And that is always helpful in the deliberation process.
Awesome. We're going to hold the questions for a few minutes, and Lisa and Rachel and Mira hopefully will be around till the end for all the rest of the questions, because we have 3 people coming up now who've actually received clemency, and I just want them to touch on how that process worked for them. Our first one is LaToya Baines, and she's the mother of 2 and a clemency recipient. In 2012, LaToya received a 25-year sentence for second-degree murder. She would have had to done half of that time. She was only 24 years old. And LaToya, this past September, was granted a clemency and came home. So, LaToya, are you here?
Yeah, I'm here.
Okay, tell us about what that looked like for you.
Okay, I'll tell you my steps. Thank you so much for this opportunity. I am so grateful for this. A special thanks to Naji, because she was the reason for it. And she was actually the reason that I did my petition for clemency. So I'm very grateful to her. So I filed my clemency in January of 2020. I was supposed to be on the April docket. And due to COVID, it got pushed back. My clemency was a little different. I did not have a lawyer when I did my clemency. I did it all on my own. And how I did it was I had to first take the steps of getting my criminal background from B of I. I had to get my disciplinary report. I only had in a total of 9.5 years of being incarcerated, I only had about 4 tickets. I also, I talked to my family about it and let them know what I wanted to do. And I had my character reference letters that included my character as a person, how I was before I got incarcerated, the things I had accomplished while being incarcerated. And I had a total of 32 character reference letters. My clemency went a little different because due to COVID, I had what you called an NBOC hearing. Miss Lisa, am I pronouncing that right? NBOC?
Bonk. So you got your sentence was commuted to life, not life with the possibility of parole, but how did you get an en banc hearing? Because I knew I'd recognize your name. That's why.
Yeah.
Yeah.
I'm not even sure, Miss Lisa. In January, when I found my clemency in 2020, I was on the docket for April. I ended up also having a meeting with the chairman of the board, an interview.
I remember your case. I remember your case. I don't think I presented you, but I don't present you, but I remember your case because I remember your family being there.
Yes.
When they came to Springfield.
Yes, they did.
Yeah, I'm excited.
Yeah.
I'm so excited. Congratulations. I remember this now. I remember this. This is awesome. I don't want to take up no more time.
Okay. I'm not really sure why I had my hearing that way, but I did receive a letter in January of 2021 that the governor had commuted my sentence and that I was gonna have this hearing. So I actually had to wait. Yeah, I waited a year and some change to even get the hearing. So when I had this hearing, I then had another interview with the member of the board. And at this interview, I was able to have 3 witnesses present to speak on my behalf.
Who was that person? Who was that person who was the person that interviewed you?
Oh, I can't remember his name. He was
It was a man.
Yes, he was a man. And he was great.
I remember that. Your babies were there too. Your babies came to the hearing. I remember. I think we were all crying. Yeah, I remember that.
Yes.
I remember that. Yeah. That's awesome.
Yes. So when I had my hearing and my family, my son spoke on my behalf, my mother and my dad, we thought that it was done. Like I was gonna go home, but it was another step. I had to be presented in front of the board. So my first meeting was scheduled for July. My family signed up. We didn't know, like I told my mom, I said, well, have people in support of me, so I need you to sign up. So people signed up on my behalf. It's a very good thing when you have family support, like they stress, because that shows that you're built from a strong community, that people are standing with you and they look at that. Also, my family called. They called a lot. And they actually, one thing I'm so grateful for the board, they responded back to my family. They called them and they let them know that, you know what, she's here, but due to COVID, things are a little slower. So when I was supposed to have my meeting July 29th, they thought everybody was coming to this meeting. We didn't know that they had to be there, so I got rescheduled. So when I got rescheduled to September, that's when my family went to Springfield. Someone was there to represent me. And my mom and my pastor spoke on my behalf. My pastor, your community is a big thing too. You have, like they stress, my community, my church family were very supportive for me. My family friends were very supportive for me, my family. So I had a strong support system in this process. And I got released September 28th. Actually, I got called to clinical services and was told I had to call the board. And my son, when I called the board, Miss Kathy told me someone wanted to give me a message, and my son told me I was coming home. So the process for your clemency is not hard at all. It's just the steps of actually putting in the dedication for it and doing the footwork for yourself. Was it hard for me? Yes, it was, because I had to open those doors, but it also was a step towards my healing. So you do not need a lawyer to do it. I actually did my clemency in between working. I was working industries at the time. So in between my work schedule, I would go to the library. So I took, in between that, I made sure I made time to get my clemency in on time and take the steps to the process. And a year later, I was home.
Yay. That's awesome. I'm just
I'm
loving this.
so excited for you. I am so
Thank
I
you.
got tears. That just blesses my soul because I knew I recognized your name and I remember that day. I remember your pastor. I remember your mom. I remember your kids sitting there. I remember the vote, and I want to say it was a unanimous vote. Do you remember your vote?
I got 13 out of 14.
Yeah,
13
yeah,
14.
yeah. I wonder who I could put my finger on the forehead of the person that said no, but that's okay. But I'm just, I remember that. I remember that very, very well. Congratulations. It's so wonderful to meet you. It is so wonderful
It's
to
so
meet you.
wonderful to meet you, and I am so blessed and thankful for the work that you do because
Yeah.
it is awesome.
Thank
It is
you.
awesome, and I appreciate it so much
I
because
love,
it's by the grace of God that I was able to come home 2 years early.
Yeah,
and I really thank you. Please thank everybody on the board for me.
I will. I promise you. I promise you. I'm gonna call folks tomorrow and say I will call everybody except one.
And I mean, I came out within the first month. I had my car. I had my license. I have a job.
How old are you?
I'm 34. I'll be 35 here.
Okay, you have a son and a daughter.
I do. My son works with me. I'm establishing my own cleaning company. So my son has his first job with me. We work together.
Awesome. I'm excited. I'm so excited. Okay, we gotta take up no more time. All right.
Good story. Good success story. I love it. And our next person is Susan Warsaw, and she is the mother of Avery Warsaw, who entered the Illinois Department of Corrections March 12, 2016. And he received a clemency in November 25th of 2020. He was able to come home. And I'm going to have Susan as a mom share. Avery wanted to be here too, but he actually had some work commitments. So yay. But we're going to let Susan share what clemency looked like for her.
Okay.
Are you there? Oh, there you are.
I'm here. How do you can you see me, or am I just little, or am I big?
Well, you're little, but people can make you big if they want to click to speaker.
Oh, no. Okay. Cause okay. Anyways, my son Avery, he has physical therapy on Monday and Wednesdays. He has a work-related injury. So God, I don't even know where to start with all these great stories, but, all right, I got to keep putting my reading glasses on and off. Okay. All right. My name is Susan Warsaw. My son Avery is 27, and I have another son, Caleb, who's 29. My husband passed away from ALS in March of 2015. So at the same time we were dealing with his illness getting worse, we were dealing with the court system, Cook County, and well, okay, I'm not even going to get into that. So my son Avery, he was arrested in April of 2013 for felony home invasion with a firearm. There were 3 other defendants with priors. He was out on bond until November 26, 2014, when he was arrested on a second case, but that ultimately was reduced to a misdemeanor, so it was bond on bond. So he was in Cook County Jail for 16 months. And the reason why it was so long was that we had a lot of 402 conferences. We had a judge who was like, okay, and don't worry, we did not put that in the clemency petition. We didn't blame the judge. Well, first of all, that judge no longer is. Okay, so if that tells you anything. So, but at the same time, my husband's condition, he started to decline. So Avery, like I said, was arrested on March 26, 2014. And the irony of it was that he was released on, November 26, 2014. The irony was that he was released on November 25th, 2020. A little background on that. So, all right. So Avery was in NRC for a week, then he was in Shawnee for a month or so. So he ended up in Dixon. Okay. As far as the petition, it was in December of 2019. Simultaneously, he was filing with Cook County for a reduction in the sentence because of the juvenile sentencing rulings that had been happening. Avery was arrested, and his sentence was Class X, 6 years plus 15 for the enhancement. So that's what we were trying to get rid of. Nobody was hurt. It was basically over sentencing. We had clergy, we had political representation. We had a lot of people on Avery's behalf. So anyways, when it came to the processing of the clemency, it was kind of like a crapshoot. Let's go with Cook County, and then let's go with the clemency and see what's going to stick. As far as that, we did not have a private attorney for that. We did it on their own, on his own. Avery was like, if you ever saw Shawshank Redemption, if you ever saw the way Morgan Freeman took Andy Dufresne under his wing, okay, this was kind of like the case with Avery. There was a gentleman there who was, he has passed away because of COVID and other things. His name was Watson Gray. And he took a liking to Avery and said, hey, kid, you don't deserve to be here. So basically what he did was helped Avery draw up that petition. They got what they needed from the county. And yes, the petition for clemency was similar to what Avery said. So he went through that whole thing there. God, I don't even know what else to say here. So the petition was received in January of 2020. We got a letter from Mr. Finley basically saying, guess what? Everything is in order. You need to get us a bunch of letters of support or whatever the documentation for the public hearing, and we will have a public hearing on April 9th. Well, the public hearing was not to happen because of COVID. So we were kind of going blind with everything. So we had to get a bunch of, I put together a very extensive package. I went out to Facebook and said, anybody who knows us, can you, we are going to need your help. Here's the docket number. I reached out to people individually. At one point, I had 2 printers and 2 computers going on, taking the letters, making them PDFs, putting together a package. I don't know if you can see this or not. Can you guys see this? What this is this was a spreadsheet. Okay, I'm in financial services, so I have to be organized. I put together this spreadsheet, and we had 56 letters of support. And these were very heartwarming letters talking about Avery, the father who was, dying at the time, just how he had, I wouldn't say blossom in prison. I mean, he took a painting, he worked all the time. I mean, the people in the office loved him. I mean, he was just that type of kid. So we were very fortunate. I didn't hear anything. On July 28, 2020, I sent another letter to Chairman Finley. I was just throwing out everything. I sent out emails to governor's office. I was just, you try to do what you can. I even sent an email to Juliana Stratton's office saying that, oh, by the way, I work with a sorority sister of yours here at Merrill Lynch, and mention the name. I was very fortunate because we have a lot of family support. We had a lot of clergy support. We had a state representative who's now a state senator, Laura Fine. She wrote a beautiful letter. We had the former police chief of Glenview write a letter of support. So just putting together with the clemency package, I had the letters of support. I had Avery's grade reports. I had a certificate from Lakeland College. I had a couple of his paintings. I printed out pictures of the house, like this is where he's going to stay. People said that, yeah, I can't offer him a job, but I can have him work part-time. Let's see, what else did we do? And he was, I reached out to John Howard Association, Jenny Bolin Katz. That's how I got to Illinois Prison Project. I just basically called anybody who I can, just to try to get it. Like they say, throw enough shit against the wall and maybe it'll stick. So Avery's sentence was commuted to time served. On paper, he had like another 4.5 years. And one day I had just talked to him earlier. It was November 23rd. I was working at home. And then he calls me up and he says, yeah, Mom, I'm being released. And I said, okay, I'm not going to use the word, but I said, you're freaking kidding me. Okay. And he says, no, I'm not. He says, honest to God, he says, they're releasing me. He had just come home from work. Then they called him back to the office and they said, hey, Warso. And they said, you're being released. And the women in the office, they basically said, if it wasn't for COVID, we would hug you. Okay. I mean, and they said, you're one of the good ones. Okay. So we were very, very fortunate with that. So after that, I immediately texted my cleaning lady and said, you need to come to the house like now, because I knew that somebody would come do a site inspection. I mean, the whole thing was just happened very quickly. And I don't know how it happened. I mean, to have this happen from when it was filed with the PRB to when he was actually released to be 10 months, that's pretty phenomenal. I don't know, maybe they just got sick of looking at these, you all say to make those letter brief. Well, mine weren't, and neither was anybody else's. But, they're good though. They'll probably make a good book sometime. I don't know.
There we go.
So what else? Avery is doing very well. He's got a girlfriend. He's probably going to marry her. Okay, that's another story. He is working. He's been working consistently. He's always been resourceful. The DMV was shut down because of COVID, but he managed that. He's adulting. He was very remorseful. I mean, he was impetuous. I mean, the letter, I'd like to read the letter, but I'm not. But I mean, he took accountability from day one. And he basically said that I was 18 and I screwed up. Okay, I was a little high at the time too, and he took accountability, and the letter that he wrote to the PRB was kind of like, and why should you take a chance on me? Well, let me tell you why. He's very articulate. And, he's very grateful for everything. And he was very grateful for the support. And I told him if he screwed up when he got out, then I would probably not be in a good situation. But so I said, I'll probably kill you. But he is just very grateful. And he was being in Cook County Jail when his father died and not being able to be here. I mean, we were fortunate when Howard was dying that we had 2 lawyers and 2 motions and 2 judges and a couple of state senators, one who knew Tom Dart pretty well, to push up to get a supervised release in which my son got to see his father, Cook County, 7 Cook County sheriffs with the dogs and everything. And they had a supervised visit and my husband died 6 days later. So I guess the whole thing, the reality of it and the remorse and the maturity level. So, I just think that possibly the Prison Review Board looked at it and said, here's a kid, here's a rehabilitation, here's a remorse, etc. And I'm just very grateful for it. Can I say, did I cover everything, Julie?
You did awesome. And I'm sure there'll be some questions. So thank you. And that was short. I know sometimes people get a little discouraged with how long it might take, but
I'm very impatient. Now, at one point, I didn't know the whole process. Okay, so I read somewhere, so I sent an email for the Freedom of Information Act, thinking, well, okay, FIA, I should be able to get this. So like 5 seconds later, I get a call from the general counsel, and he says, okay, it's there. I had called and I had spoken to Melissa, and because I remember the name, and she says, it's here, everything is fine. It's like, well, can you tell me more? No. Okay, and then when I talked to Jason Sweat, he says, I don't care how many times you ask me, I'm not going to give you any more information. You're sounding like a reporter. And he said, I will say that letters of support do make a difference. It's a lot better than getting one of those change.orgs where you get 10,000 people to sign a petition. And yes, they read the letters. And from what I understand, it was in the governor's office around early September. So, you know, I tried, I thought just because I was sweet and nice and persistent, maybe they'd say, okay, get her off my back and give her the information, because I had no idea about the protocol. But somehow it worked.
And I want to say it was really nice for Susan because I think that Avery was released like 2 days before Thanksgiving. So
It was amazing. And the people from the office, I mean, they really, and then I wouldn't say I kept in touch with them. I said, you know, you guys were so nice to him. I mean, I'm not saying that I'm going to write a Yelp review and say I want to go back, but they just really were, they were very kind. And, you know, when I picked him up, the first thing we did was stopped at the DeKalb Oasis. I had brought him clothes. He threw the stuff away, and, you know, he learned how to use my Amazon account pretty quickly.
there you go.
And
That's-
after the parole officer came that night or that late afternoon, he got the phone, and then we just kind of moved things around. So it was a great.
Thank you. And I know we're getting our time here, but and Kay, I know you have your hand up and we're going to get to your question, I promise, but our next is James Swansea, and I have the pleasure of working with James, who did a long time in prison. He did 28 years. I believe he had a 30-year sentence, and he received his clemency. I think December of 2020. So where are you, James?
Exactly. Right here, Jules.
There you go.
Yeah, I did receive my clemency in December 9th, actually, 2020, after serving 28 years. Former juvenile lifer. That's how the whole process got started for me. The whole resentencing aspect. So I was blessed enough to have a law firm represent me pro bono, dealing with the whole juvenile aspect. So I had a good support system going in on the legal side. Not everybody is blessed like that. So, and with the whole resentencing phase, I ended up going from natural life to being resentenced to 80 years, which we all know is basically the same thing. Basically what the judge told me was that, well, at least how I took it, I felt like he told me after serving 25 years, I needed to serve 14 more, you know, just in case I wasn't ready to re-enter. So I definitely understand the length and how things can seem like it's taking forever. Even after the time that I served, after I actually got found out that I got granted clemency, because I did come home ultimately on clemency, the governor commuted my sentence to reflect the time that I had served. So kind of like what Rachel was stating too earlier, you know, the governor has the power to do exactly that. So I had like almost 27 years in, so he commuted my sentence to match that. So I ended up with a final sentence of 54 years, and I ultimately did 11 months too much. So that's kind of like an immediate release type of thing, but it didn't go like that for me, fortunately. I ended up finding out that my clemency got granted on a Friday. So, you know, the whole COVID thing and all that. So, so I really had to wait, you know, me knowing that, you know, it really was true. And so ultimately what I found out that I was waiting on an actual signature, just one signature. It took 5 days to get one signature to Stateville. So, like I said, after 28 years, those were the longest 5 days of my whole incarceration. Just, you know, and just so to speak, since he came on camera, the best thing about that is I had another impacted individual by the name of Wendell Robinson that actually came to pick me up, you know, so just that support system in itself, you know, and I don't want to take anything away from mothers, sisters, brothers, or anything. And I know, you know, people want their loved ones to come home, like Ms. Daniels stated earlier. But, you know, just walking out that door to individuals that knew what it was that you were walking away from and walking into. So, I think everybody should just take this training, you know, as what it is because it's very informative, because the support system, period. You know, just showing them, like they said. And we actually had a chance to actually sit in on a clemency hearing a little while back. And so I actually got to see what it is that Ms. Daniel is attesting to. And, you know, it is a public hearing is basically what it is. It's you have the board, you know, then you have the table that the people that you want to speak on your behalf. Then, like you said, you have the people with the t-shirts on behind you. And basically the hearing is, all it is that everyone gets to hear the case in itself. So you're not just speaking to the board, you're speaking to everybody that's trying to do the same thing that you're doing. You know, and everybody is attesting to how their loved ones change. But my advice to you is the proof is in the clemency. You know, if they can attest to anything, you know, if you get those certificates and you know that you've done the right thing, there's nothing that IDOC or the state's attorney can do about that, regardless of if they bring up the facts of the case. You know, if you know in your heart that you're doing the right thing, and you know when you come home, you're doing the right thing, then things will eventually work out. You know, it may be more time consuming than people think, you know, because it's a lot of things going on. There's a lot of people that have come home, you know, and I know everybody wants to add to that story, but I just ask that everybody stay, you know, patient, because I think it's a lot of good things that's getting ready to happen in the future as far as with clemencies and, you know, it's a few other things. So that's definitely a good thing. So I appreciate everybody coming, and thank you.
Thank you. And we're going to do some questions. And I would ask that, you know, obviously you can ask Ms. Daniels or Rachel or Mira or Susan or Latoya or James, but if you don't get real specific about your case, because we can't really do that, but if it's more like general, like how many letters did you have or how long did it take? Or you know, I'm sure you have some very more targeted questions in that. It's just that I know we can't actually do case by case on this type of platform. So I know Kay has had her hand up for like a really long time. So I'm going to just ask you to unmute and ask your question.
Okay, I guess my question isn't really a question, more of a comment and a reporting of our family's experience. Well, our family submitted emergency clemency petition on behalf of my son-in-law, who is incarcerated within IDOC, and he was aware throughout the process of what we were doing on his behalf. It was in June of 2020 that his petition went in, and of course that was in the midst of COVID, and so there was no hearing, but his petition went before the IPRB in November of 2020, and a confidential recommendation went to the governor's office in January of 2021, and he has heard nothing, no communication about his petition. And, you know, I mean, Julie, I see you there. My daughter and I have been very involved in Illinois advocacy groups, Restore Justice. And I really want to thank the Illinois Prison Project for putting a toolkit for families on their website when we were submitting my son-in-law's petition. That was so helpful to us. And I've also dropped into some of their office hours sessions when I've had legal questions. IPP is awesome. Our family is involved with a family updates group through Facebook. And we've also, I mean, I have done everything I can possibly do. I work in state government in another state. I'm a workforce development advocate. So I've worked with incarcerated individuals. And So this is very personal to me. And I think we've just gotten to the point where, and I don't mean to be negative, but we've gotten to the point where we're broken. Right now, my daughter has been apart from her husband longer than she was ever with him. You know, my granddaughter was 1 year old. She had just celebrated her 1 year birthday when he was taken from us. And like Susan, I hesitate to get into, you know, what it's like to, as a family member, to deal with Cook County court system, and now, you know, he's had COVID twice, and he has serious health conditions that have not been addressed. There's a humanitarian crisis in the Illinois Department of Corrections. There have been riots, continuing violence, setting of fires, hunger strikes. And
Okay, I'm sorry. I know, you know what, and a lot of people share my, you know, many of the people here know about the jails and the prisons and the, you know, I mean, definitely, I'm not minimizing it at all. Okay.
no, and I know, I'm sorry. Yeah. I just
I know, and I
think
I actually have like our crit group, which I'm gonna invite you to after this, so because that's kind of where we do this, you know. But anyway, I know Alyssa said she had a couple questions in there. I'm, you know, and I'm sorry to stop, but we don't have too much time left. But thank you, Kay, and I'm sorry.
Actually, before I go, Angie's had her hand up, so I want to make sure we get to Angie, and then I will read some of the ones I saw in the chat that we haven't answered yet.
Hello, can you hear me? Hi, I'm Angie. I'm new to this. I found out about this on Facebook. I've been trying to do the clemency for my husband who incarcerated. He had a 75-year sentence. And I listened to everything that y'all did, and I noticed that I did everything wrong in the clemency petition. Not that the docket, I got a docket number, I did all the check marks, but as far as doing his character and getting family support letters, and I thought a hearing meant you had to have a paid attorney. I didn't know that a hearing was just you speaking on your loved one's behalf. Like, I was like misinformed by a lot. So I heard the lady said that she got a lot of interviews or callbacks and stuff. And if you don't get any of that, do that mean that the governor said no? And if that's the case, how can you, if you said it was a waiting period. So say we wait and then here come election time and we got a new governor. Do I have to refile because I messed that one up? Or I'm kind of lost. I need some help.
Yeah, I'm hearing you, Angie. And I just want to say, like, you know, everything we're saying in this hearing, it's stuff that we've learned as well. You know, I mean, it's all sort of best efforts. So I don't want you to have a takeaway from this hearing that you've done everything wrong. I'm sure that's not the case. There's always stuff that we can do better in clemency. But I don't want you to have the takeaway that you've done everything wrong. So a couple things. I would encourage you and everybody in the call to come to our Illinois Prison Project as a legal clinic twice a month for loved ones. And I'm going to drop the link in the chat right now. For your questions and for other people that had like really specific questions, I don't know if Chambers is still on the call, but I noticed you had a couple of like really specific questions. Those are really good questions to bring to our clinic. We can get into those deeper questions one-on-one with an attorney. And so that might be a place to ask some of them. But in general, to answer a couple of your questions, one idea for you may be that you want to supplement. So I talked a little bit in the chat about supplementing, like sending like a late letter and some late attachments. That might be something that you could think about doing. We do that a lot. And if you want to join a legal clinic, I can walk you through a little more, but it's essentially a letter that you file in the same fashion and documentation, you know, supporting that with any updates or additions, things that you realize now that you wish you had included. And then the other thing to know is that, unfortunate, if you haven't heard anything yet, and if your loved one hasn't heard anything yet, so if you file pro se, the denial will go to your loved one, right? Because technically they've filed it, right? Even if you helped logistically to file it, they filed it. So the denial will go to your loved one. If that hasn't happened yet and you haven't heard anything, the answer is that it's probably still pending, and things can pen for a very, very, very long time. And that's with the governor's office, right? That's past anything that Ms. Daniels and her colleagues work on. That's at the governor's office level. If you haven't heard anything, it's really frustrating, but you're also not alone. A lot of people are in that boat, especially right now. So I don't know. I saw Ms. Daniels on mute. I don't know if you had more on that.
I just had a question, Angie. Maybe I missed it. We're talking about your husband, right? Yeah. Has he had his hearing yet? Or did you, you said you got a docket. You said you got a docket number. Has he had his hearing yet?
I think when I called, it said he had his hearing back in March before. Last March.
March of 2021.
Yeah.
Okay. All right.
But he said he couldn't tell me, and everything was over to the governor. And then I got scared because I'm like, okay, well, the governor didn't say nothing. So
right.
I think so.
Right.
I didn't know about character letters. I wrote a letter of support for me as a wife, but I didn't know I was supposed to be showing you who my husband was as a person. I didn't know that.
So there was so you did a non-public hearing. You didn't come. There was no in-person.
No, because I thought a hearing you had to have an attorney. I'm thinking.
Oh, so you asked for a non-public. Okay.
Yeah, because I could not afford to pay for an attorney.
No, I completely understand.
When I said, "Oh, public hearing, I can't afford no lawyer. Can we do it without it?" You know, and it was like, "Well, yeah, you can do it without it." I'm like, "Okay, great."
Okay. Okay. I got it. So Rachel did a great, that's great. You should probably go to the next legal clinic and get all the information you need and all your questions answered. IPP is fantastic. You're in Chicago, right?
Yeah. Okay.
Yeah. It's gonna be okay.
I think Rachel dropped that link in the chat, and I will also, this is Alyssa with Restore Justice, and I emailed everyone. I will make sure I email that link out to everyone as well with all the IPP information. They have their toolkit, they have their hours. One question that we got is, if a petition is denied, how long does a person have to wait before they can file another clemency petition?
1 year. It's a 1 year waiting period from the time of denial.
Thank you.
And then I think the only other question that I haven't seen that we answered, and we may have answered it, I just want to make sure, is, are there a certain number of petitions heard at a hearing, and are there a certain number heard in a quarter of the year?
I don't know if I know that number. I don't know, Ms. Daniels, if you know that.
The number of petitions that are heard, there is no certain number. No, there are whatever is on the docket for that day. But no, there's no limit. I think that's what I'm hearing the question asked. That might be what the question that you're asking. There's no limit for the number of petitions that are heard in a day. Like, there's no cap. So yeah, sometimes it might be, that the session that just got canceled due to COVID in January, the Springfield session, was the largest docket. I think we had over 500, almost 400 cases to be heard in a week. And that's unheard of. We usually have 3 days, maybe 4 of public hearing, 3 days of public hearings and the 4th day of private hearing. And this docket, we were going to have 5 days of public hearings. So there's no, right, so there's no cap.
And someone asked if, I'm repeating it as them, if I have the power of attorney for my brother, can I sign on his behalf?
Yeah, that's a great question. We had said no, but Ms. Daniels, do you have a different thought on
I
that?
don't know. I don't know different. Again, that would be a question for the coordinators that work in the office.
Mm,
And then
mhm.
someone asked how you know if Clemency is right. My suggestion would be to go to the IPP legal clinic we talked about. And, I think that is an opportunity to get a little more specific because I think that's probably an answer that's going to be different on a case by case basis.
I agree.
And someone asked a good question. I just want to share the answer really quick because of the election season. Someone asked if we have a different governor and you have filed, if you have to refile, and the answer was no. I just wanted to make sure everyone saw that.
Oh, that's good. That was a good question.
That is a good
Yeah,
question.
it's a really good question. Yeah, that's a really good question. And a lot of times what we've seen historically is that a lot of petitions are decided when a governor, including positively, when a governor is leaving office. But it has been true of past governors, they leave a lot of petitions, and for better or worse, those petitions just simply wait for the next governor to come into office.
So I have one more question and then we'll wrap up because you're all working overtime and I just can't thank you enough. But so if we change governors and yours has been sitting there maybe for even 2 years or something, can you file another petition even though you haven't been denied because it's taking so long?
You cannot. And that's a really important thing to know, right? So once you file, what you filed is what you're stuck with until a decision is made. You can file what I myself call a late supplement, which is right. So a supplement that the Prison Review Board can't look at anymore because by law, they're done with it. They've done, they're within 60 days of the hearing, public or non-public, they've given their confidential non-binding recommendation to the governor's office. But the governor, again, it's a very broad power. So if the governor wants to consider additional materials, they absolutely can. And the way to get additional materials in front of the governor would be to file a late supplement. You do that the same way. So, essentially, if you email it to the Prison Review Board, they will pass that along to the governor, even though they can no longer consider it themselves as part of their recommendation. So I wouldn't do that with small updates, but I would certainly do that with major updates. Someone's got a degree, someone's got, unfortunately, severely worsening health condition, that sort of thing.
Well, I'm just going to tell you that I don't like that answer, but dang it. Well, we're going to wrap up because it's past 8 and I apologize for being a little bit late, but if you would like to connect with Restore Justice, please join our advocacy team. You can go to restorejustice.org. We meet weekly just for a half hour to kind of talk over. It could be a bill we filed. It could be some prison conditions. We kind of, and different types of outreach you can do. So we would do that. And we have a couple more upcoming trainings. We have an in-person legislative advocacy training Saturday, February 26th. We're hoping it's going to be in person. Lindsay, is that going to be on Ontario? We don't know.
Once you
right.
register, we'll send you the address.
Yeah,
It'll be
we'll
at River North.
We do know but we'll send you the address when you register. And then our next session like this, I like to call them loved one self-advocacy session, will be Monday, March 7th. We're going to attempt to talk about transfers within the DOC. And I just wanted to thank Lisa and Mira and Rachel and Susan. Congratulate Susan, Latoya, and James. And thank you all so much. And thank you all for coming. If you have questions, you can reach out to me. And here's all Restore Justices. Thank you.
You're very welcome. Thank you for having me, everyone.
Oh,
Thank you. Bye-bye.
Thank you so much for having us.